that's okay with you. Like, you know, you don't mind which portions is being taken out anywhere.
No, everything I do is equally embarrassing. So there's no need to worry about that.
You know, if you have a feature where you see me but you don't hear me, my wife would like you to send that over, I'm sure. I think you created an OBS fan. I'll have to tell her about this. No matter how much I talked, no one heard anything. That's a dream come true here, I think.
Imagine being at the forest and can't hear the sound.
Yeah, exactly.
Okay, so we start again. You consent to be in the interview? Yeah.
Yes.
Yes, cool. All right. So, okay, let's start again. So, you yourself, you go by the title lawyer. I go by the title of doctor. I am not a real doctor. That's completely obvious. So we got to ask you: are you a real lawyer?
Yeah, you know, maybe there's been some judges that have wondered that, but in fact, it's true. And I was licensed in '94, so that's just after the Revolutionary War and when the nation was starting. So it's been quite a while. But yeah, I started out in litigation as a litigation attorney and doing commercial litigation, defended a local police force that was for one of the cities, did some criminal things related to that. But eventually I moved in-house and became an attorney for a company and got to travel around the country and Europe and stuff, trying to keep them out of trouble. That became the focus. So it was a different kind of experience. Trials are stressful, but they're a lot of fun. I mean, you're really putting it all on the line when you go to court, and I enjoyed it a lot and missed that some. So anyway, now since COVID, I've kind of semi-retired and I do some cases and things like that, but I work maybe quarter time or something like that.
Okay, so what was your expertise, like area in law? Like, was it commercial or I'm guessing it's business litigation, commercial law?
Certainly over the whole span of it. Yeah, absolutely. And then earlier in it, you know, there was a lot of governmental stuff like involving the police force and things like that. So that's aside from, and, you know, I've been in a little bit of personal injury and stuff. I just like to do different things. So I've tried. Okay. I don't like to do divorce law, and I'm not admitted in any bankruptcy court. So there are some things that I try to and writing wills and stuff is boring. I only do that for friends. So those things I don't like to do. But, you know, if it's litigation, if people want to fight, you know, that's generally interesting, whatever it is.
Oh, okay, that's fair. I need to understand this. You would say that you have a lot of experience as a lawyer. I would say, you know, practicing from '94. So how does that separate you from a social media lawyer who has been on the internet probably for this year or for 5 minutes?
Well, the way I use the term social media lawyer is for somebody who just is spouting off legal things, but they don't have any idea what the heck they're talking about. And I think I mentioned that, you know, like I can put up a statute, a copy of it, and then read it, and it's in simple words, and somebody will come back and tell me, no, that's not it, and this is what the law is, and they're angry about it. And when you find a cite for them, it's a little part of their brain that's called their imagination. And so that to me is a social media lawyer. That's somebody who just has no interest in being accurate or doing any work to research. They just blurt out how they'd like things to be versus actually doing the work to find out what they are. And there are lawyers on social media who I think are very talented people, and it's important to them to be accurate. But there's some people in the middle who they don't know, or they want to know, or they're honestly wrong. But there's this class I call social media lawyers, which are people who don't care, and it's more malicious, and they just will spout misinformation straight to somebody who just showed them what the actual truth is, like that didn't actually happen. It's weird. It's a weird thing.
Okay. In your experience as a lawyer, how robust or flexible you have to be to like different changes that happens in the legal system? And I'm trying to be fair to the social media lawyer here. They don't actually, you know, they don't know the legal system inside out as well as you do. So like how robust do you have to be as a lawyer in regards to that?
Well, I think one of the things you should do if you're a real lawyer is have some humility on the limits of your own knowledge, because we have the federal law, which applies all around the country, and then we have 50 states. Each has their own laws. Each has their own takes on things. The definitions are not the same across the states at all. They're frequently similar, but you can't count on that. And then when you learn something, somebody comes along and passes a law that changes it, or an appellate court changes the judges and they change it. And so everything you think you know before you go do something that matters, you have to check it. I mean, when I was first coming into practicing law, the guy I worked for, the partner, he would always say, "Did you check this? Did you check this?" And I'm like, "Dude, I mean, that's old law, bro. Just, it's not, they're not going to change it. Check it. And every once in a while, something has changed, and you do not want to wander into court in front of a judge and cite the wrong law and lose credibility and malpractice and everything else. And I don't mean to be unfair to aspiring social media lawyers who may have a thought of what the law is. The ones I don't like are the ones who insist they're accurate. And then when you show them where they're wrong, they just get angrier and they don't want to know. There are some people who don't want to know the truth, and are they paid trolls, or they just are upset because their basement humidity is too high. I don't know why they are like how they are, but there are some like that.
Oh my God. The way you slaughter these people with your I'm sorry, the humor is very dry on this one.
Yeah.
But I gotta say, so I know I've seen quite a few people like this talking. I think there was even a whole discussion in regards to the settlement, in regards to the Depp v. Heard case. We saw a litany, in fact, an army of social media lawyers, all in one, and a mix of real lawyers.
And there's, that's an area that actually is confusing. And so my first experience with this, because I kind of watched a little bit of one trial and then started getting into this one, and I didn't make any comments, I think, to the end of this trial. And that was when they said that Amber Heard couldn't appeal unless she posted this $10 million bond. And that made sense to a lot of people. And the way the judge reported it in Law and Crime, you would take that as accurate. But the actual statute is pretty clear to me as a lawyer. And however, I understand why people thought, so that to me is an honest dispute. People would even take correction on it sometimes, or they'll just go, well, I have to see, or whatever. But the law really was confusing there to people, and the way it was worded from the judge that got reported. So to me, there was a lot of honest confusion there. And, when appeals are settled and things like that, people don't necessarily understand how that works. And it can be different on every state, and it can be based on how the parties resolve it. So you are down a lot of rabbit holes when you're talking about legal issues like that. It does get pretty complicated.
No, that makes everything you said. It makes absolute sense, because the reason why I asked that question the way I did, it was to kind of try and demonstrate the nuances when it comes to the legal system. And my next question would be, because you did say that you watched this trial. I want to know when did you actually start following the trial? Like, was it on the inception, or have you heard about it beforehand, or was it after the trial then you went back and what's the history there? Because there's a lot of legalities in the trial that I really want to hammer down, because it is incredibly nuanced when it comes to defamation. In my opinion, I'm not a lawyer. I just thought, let me just disclaim that now. I am probably the fringe of the social media lawyers.
Well, my experience with you of course, is that you are trying to learn what the law is for the things you're interested in knowing. And that's what a real lawyer should be willing to do, too. I mean, I didn't know Virginia law watching this case, because I don't ordinarily practice up there. So I started watching this case sometime when it was in progress, and not before. I didn't pay attention to any of the pretrial motions, in limine things, what would be excluded before trial, or whatever that normally goes on in a case. But I started watching it more because of the YouTube lawyers who were reporting it. I was enjoying listening to them in the background. And then Depp has so much charisma that, although I'm somewhat of a fan, when he was on TV, I just enjoyed watching the guy. And I thought the judge was good. And this case, courts, is big because you had a collision between Me Too believe all women, and those kind of slogans, and what's the limits of that. And so this case was an avatar for this larger social issue. So then I ended up watching it kind of like a lot, which wasn't any plan, because I'm getting, but I did do it. I did watch it a lot, and I couldn't keep my mouth shut at the end of it, and started talking about, no, she doesn't have to have a bond. And now I have all these YouTube videos up. So it was a descent into madness, I think, that many people have had.
I understand. So before we delve into the legalities, I want to know, you just said about your YouTube channel. Did you set up your YouTube channel just to spite Amber Heard?
No, I did not. Actually, I've had this channel for a long time, but it was more to do with other things, because I used to be a competitive shooter. And so I would put up videos about making ammunition or making fun of, competitions that we were in and stuff like that. But I don't have anything against Amber Heard as a person, and certainly don't think she's done anything here that other people haven't done. Now, as the trial progressed, I believe the jury got the right verdict. I believed Depp in this case. That's they had to believe him, and in order to come to the verdict, and I did too. But I don't, despise her or anything. There were a lot of people encouraging her to do what she was doing. That's for sure, and a lot of rewards for doing it. And I don't think she should be a reason why anybody who does suffer abuse, whether you believe she did or whether she didn't, that's no reason for people to fear protecting themselves or contacting authorities or doing what they need to do to protect themselves. Even if she did lie in this case, which I think she did, that doesn't suggest other victims are lying. It's case by case.
I personally agree with that. So why did you start your YouTube channel then?
Well, from the law side, what I thought was, here's a space where there's an area, there's a lot of good trial coverage I think other YouTube lawyers are doing, but I thought, there's a space here to talk about just legal issues without coming into it and saying, well, look how dumb she is, or she's a big liar, or he's a big liar. Because there's no shortage of the national supply here of opinions is quite robust. Strategic opinion reserve is always full. But I thought maybe I could help people understand what legal issues are. And so that led into going into the Marilyn Manson case, because that was a case filed after Depp that I read it and I thought, this isn't it was reported as being just like the Depp case, but the legal posture of it was significantly different. And I'm sure you've seen, as that's evolved over the period of time since that litigation was going, it's not gone the way that Depp Heard has gone because of all these legal differences. So, I think helping people understand, why would a court do this, and why did this happen, without saying, well, I know this person did it or didn't do it or whatever, because everybody, my opinion on facts isn't better than anybody else who's trying to make an honest factual analysis. All I can bring to the table is researching what the law is and trying to apply it to the posture of the case. Okay.
So my questions failed. It wasn't to find out if you definitely spite Amber Heard. Then you don't spite her.
I do not. I don't know her.
That's fine.
Or know as much about her as other people do. And I think it's too bad that her life brought her to the intersection of where she and Johnny Depp ended up in court like that. I don't think her case was fully honest, and I think the jury detected that. Yeah. And that's why he was able to win. I bought him over her, that's for sure, in that case.
Oh, fair enough. So I have watched your channel, and I only watched the recap. So I was quite interested because you did cover the Darrell Brooks case. You live streamed that. I am more interested. How come she didn't live stream this one? Because there was a lot of YouTubers live streaming it, and the reason why I asked those questions before is because there were many media hit pieces, and there were many media articles that were saying that YouTube creators and etc. are profiting from misogyny, and there was a lot of hatred towards women. And and it was just a cash cow for a lot of people. Why didn't you jump in and invest in that cash cow?
Well, really, I was watching it. I mean, I was enjoying the people who were doing it, and the channels that I saw doing it certainly were pro Johnny Depp. Uh-huh. But as the case went on, I kind of was that way too. And you could watch it without the commentary. You can watch it with it. Everybody had their choice. I don't care if somebody makes money on that or not. Media is into business to make money. So it's a little hypocritical of them to report on YouTube people as if the money part of it is somehow wrong. Now, if it's misinformation or lies or things, that's different. But if an attorney has a channel, or somebody who's not an attorney has a channel that's giving commentary people want to hear and they make money on it, the money part to me is first, none of my business. And second, I don't care. I mean, it's people that work at CNN, they don't work for free. They just enjoy destroying the country, sure, but they also want to be paid while they're doing it. And that goes for all cable news of any stripe, in my opinion.
I personally think it's unfair for a lot of the YouTube lawyers that did cover this case. You know, there was quite a lot of them, and people learned a lot about law. There were even people, you know, gaining a lot, you know, just became enthusiasts. I'm not sure if I'm pronouncing that correctly, literally overnight, because this information has always been in a way lock and key, because it wasn't shared the way he was being shared through this trial. So what I saw that should be a beautiful marriage of information coming together, like, you know, like the legal side finally getting the exposure it's been waiting on, so to speak. It then became a circus, if I could quote that properly, where it's been spun, and people like Emily D. Baker and I think Legal Byte, etc., they were thrown under the bus as grifters. While that's established, I want to ask, was there any way in which Amber Heard could have won this trial? Anyway, based on what you saw, based on the evidence that was presented during trial, all of those things. With your experience, if you were representing her, how would you have turned it around?
Well, I think she could have won because in theory, the jury was just asked to decide which side is more likely than not correct. There's no beyond reasonable doubt in these civil cases. So in a civil case like that, it comes a lot down to, well, of course, it comes down to evidence. But when you're talking about what happened a long time ago, a lot of it is credibility of the witnesses. And my assessment was that Depp had more credibility than she did. And I think his experts came off better than her experts. And so the credibility side of it to me was, well, if I wasn't there and I got to believe one side or the other, I'm going to believe him. And even though she did have pictures that she said showed some of the abuse and things, that I think his team was able to show that's not so clean cut. And now you don't just have a picture, you have his team convincing me at least that picture is put forward in a deceptive way to try and support something that really the picture doesn't support. So I had a hard time buying her story.
The Vanity Light pictures, isn't
it? Yeah, absolutely. And I take it like this, you know, for these Hollywood people and for a lot of people anyway, they're drinking a lot, they're doing drugs and stuff. You know, the odds of him never yelling or doing anything he shouldn't do, that's pretty low. And same thing for her. So you have to ferret that out and say, well, what was really going on in all those circumstances? And you know, she was definitely running him down in the op-ed, which was one of the legal issues. How do you know it's him that she's talking about? I mean, of course, you know it's him, and the judge bought it, and so did the jury. So she could have won just by having the case be more persuasive than his. But, you know, you would have had to reduce the credibility of Johnny Depp. And that is not easy to do because people like the guy. I like him. If I were cross-examining him, I'd still like him. It would be hard to make him look bad, I think. And instead, sometimes they made themselves look worse, I think.
I'm glad you touched on the likability part, because that does play a lot into credibility as well. But I guess I should caveat that by saying that it shouldn't overshadow the evidence that's being presented. In terms of the preponderance of evidence that was presented, do you think it was convincing that he did not actually do this?
Well, it must have been to the jury, because they wouldn't have found it was false otherwise. And And yeah, I think they got the right result. Now, I don't have to burden myself with thinking, would I put somebody in jail one way or the other or not? I just have to say, which one did I buy a little bit more than the other? I'm taking advantage of that civil burden of proof. And there was some evidence, but it was, it was so colored by the personalities in the trial. And one of the things we used to tell people, and I'm sure they did too, is, you're testifying all the time, not just when you're on the stand. Way before you get to the courthouse, like when you're driving there, don't cut people off, don't road rage, be nice to everybody around you, because you don't know who's looking at you. You don't know. And especially when you're in a courtroom, the jury is going to get bored and they're going to look over and see how your person is. And they have good interpersonal reactions with their team. That people like people they like, and they don't like people they don't like. And I looked at Amber Heard's side, and she just looked like she was upset. She shouldn't have to be going through with this. And I'm thinking, if the whole universe is a simulation, what are the odds that the defendant's name is Miss Heard and her attorney's name is Rottenborn? And I'm like, can you guys like hire, Ralph Good Guy to be an attorney too? Like change the dynamic a little bit. Like shouldn't she have been giving out balloons before she goes into the courtroom and being nice to people instead of scowling? So I think she didn't help her case there. Again, as you say, that shouldn't matter compared to the evidence, but humans are humans, and you're there for a show for the jury, to show them your evidence and to have them believe you as the trustworthy narrator, because they got to buy one side or the other. And they did that. I mean, his lawyers were very good too. Depp's lawyers were very good.
Yeah. Oh, it's very interesting that you brought up all these points up, because in my head, I was like, these are trial strategies that the average man, probably even some lawyers coming into, the legal field brand new, they wouldn't even think about, in terms of how you are with your team, how you're presenting that to a jury. It could be fake as hell. In fact, Camille could be fighting Depp behind the scenes. Like they could be punching each other up and this and that. But in front of them, they're like, nope, we gotta keep that. I didn't know how important that was. So my question would be like, what did you think? What are your thoughts on the legal representation that she actually had? Like, did they pay for? Were they up to the tasks that they were given, or was it just a case of it just wasn't enough for her, even if she had incredible legal representation?
Well, they were smart enough, but just in my opinion, they were out-lawyered in this case. And if it's a closed case on civil side, and so, you don't know which thing is going to tilt this jury one way or the other, then the lawyers can matter more than they matter in other cases. And here, I think they did matter. I think it was kind of a show for everybody, and how her lawyers came across probably mattered. And I think the cross exams that I saw, Depp's team did a better job than her team. And look at the experts, because you had the super gorgeous, articulate, highly articulate, everybody would listen to her all the time, expert for Johnny Depp talking about
Curry.
Dr. Curry. And nothing against all the experts on her side, but for the gentleman who was there, who kind of looked off into space for a little while, those aren't going to be equally persuasive to me if I'm sitting on the jury. She did have another witness expert that was kind of in the middle of that. But, when you're going to pay these experts a lot of money, part of what they bring to the table isn't just their diploma on the wall. It's how they tell their story. And look at the Murdaugh case that just happened in South Carolina, how the state's expert was he was a doctor, but he was a down-home guy and brought it to the level of an average person who hadn't had to see this 1,000 times. Like, how do I understand this? And he was very engaging to the jury. And so people have argued with me on Twitter, like it doesn't matter how persuasive the expert is, the evidence is the evidence. But that is a naive view of it, because all the jury knows of it is what the expert tells them, and how people tell stories is very important. I mean, that's why Depp makes the money he does. I could be in Pirates Caribbean, whatever the next one is, 6, instead of him, and I bet in the box office numbers wouldn't be as good. And even I wouldn't want to watch it. So it does matter who's telling the stories, even if they're already written.
Okay. That's a very good point. And it just made me think of, I think you said it brilliantly when you said they were able to break it down to an average man, because that is something I've also observed. It's not, to go back on the likability part, I don't think it's about likability, because she did have one expert. Why is my accent coming out like this? She did have one expert that flipping heck. She did have one expert that the hand surgeon that was doing that job quite well, in my opinion. I think he was he wasn't quote unquote likable, if I'm being honest, but the way he explained things was actually quite, it was clear cut. I actually think if the jury would side with anyone, or at least listen to anyone, it would be him, because
yes, good point.
I think he done well, in my opinion. I think the tech guy, for all the complexities, not the Apple metadata guy, but the guy that was doing the social media analytics, I think he broke it down quite well. To like try and get, Dennison was just an amazing cross-examiner of these experts, so it kind of like made them look not credible, but in terms of what they were trying to present to the clients, I thought they were great. But what did you think of people like Shannon Curry and Hughes? Do you think, in terms of DV in this case, do you think that they actually broke it down for the jury to understand what was actually going on in those audios, etc.?
Well, I think that's a good point, and I think the experts were getting a lot of information out to people. I don't think I saw all of it, but the parts that I did see, they were getting the points out that their sides wanted to make, because it's a complicated topic, and while that's one of those things you may go into it thinking, well, I understand how all it is. I know what I'd do if that were happening with me and stuff, but sometimes that's not true, and an expert can help relate the behaviors of somebody who's experiencing domestic violence or responding to it or whatever. So I thought they were doing a good job there, and particularly in the point that you're making is, for an expert, it's not the likability quotient so much as it is their ability to get that narrative and the story and the information to that juror in a way they can understand it when they're having to sit there every day listening for hours and hours. So yeah, that's a really great point.
When you have a witness like Dr. Curry, what would be the strategy? Because what would be the strategy to nullify her? Because she was very eloquent, she was very knowledgeable. She didn't even read notes or anything like that. She was just speaking literally off the rip, so she knew exactly what she was talking about, juxtaposed to Don Hughes. What would you, as a litigator, what would be the strategy to handle that?
So normally, of course, on a cross-exam, you don't want to ask any question you don't already know the answer to. So you should know what you believe that witness is going to say when they give the answer, or have something you can contest them if they give you the opposite answer. You don't want surprise answers on cross-exam, because then that's not good. So if, let's say, she's fully competent and the thing she said was true, then what I would try to do is come up with a line of questioning to get her to admit the limits of what she knows. That, well, this test, it has this limit, and this test has this limit, and leave the jury at least with the impression that, okay, she told you a way this works, but she was also honest with you and told you there's ways where this doesn't work, and then have your own expert come in and go, yes, as Dr. Curry did though admit there are these limits, and let me tell you why these limits apply. Because you ain't going to get her to tell you why she's doesn't deserve the check she's getting from the other side, because she's too smart. But if you can get her to admit limits, then you can call your own person and try and do it. Yeah, and rebut it. Yeah,
that's not a bad strategy. So does muffins work? Like, does focusing on her getting muffins by somebody actually is a good strategy?
Was that when they were trying to focus on that? She went to dinner with him once, and then she bought some muffins. No, I mean, I thought, my recollection of that was watching some of that going, what in the world are you guys? No, I mean, do you want to look trivial though? Like, I mean, you're just berating people over things that make sense and stuff. No, I would have just got her to admit the limits of what she knows. Now, if you did have some real bias there, you would want to show that and maybe leave an implication. But I was not impressed by how they were attacking her as a witness.
In your experience of litigating cases, like, is it based on what you saw in regards to Dr. Curry? Because this is kind of an over-argued point, like, oh, she was at Depp's house, etc. How is this usually handled? Like, would an expert go to someone's private residence to interview them before hiring? Because that is the context. It's not like she was hired and then she just goes there and then blah blah, but it was before she was hired and she was getting interviewed, if my memory is serving me correctly. Like, is that normal, or?
No, usually not. Now, that could be different in this case because he's famous and they want to keep it on the down low, what's going on and who he's, if there's paparazzi following him somewhere, then here's a picture of him with her. What's going on? Who is she? The defense could find out, because if they don't hire her, why not? And all that. So it may have been strategic reason there for them to do it, because I don't find that to be an indication of bias. You're going to meet somewhere. It could be dinner at a restaurant. It could be the attorney's office is more usually where it is.
Yeah.
But I don't know how they do it out there, so going and meeting at his house and having a drink while they're talking about the case and stuff, that you may want to tell the jury about that and try and make her sound bad, but it doesn't have to be a lot more than that before I'd believe, well, she'll just lie for him. Because I believe when have you ever seen a case where one side can get an expert and the other can't? I never experienced a civil litigation case where both sides were not able to get an expert to say their expert testimony established their point of view. So it's kind of baloney anyway, because this expert on one side says, yes, this person is right. And the expert on the other side says, no, this person's right. Well, how expert can they be if they can't agree on one thing? You don't get physicists up there disagreeing about E equals MC squared. Why can't they? How can there be one case where all the experts are like, no, that person's guilty right there? So there's a limit to how much I pay attention to what they say, and it's more like what you said, how instructive they are, how they explain the theories to me that the attorneys then use later.
Yeah, 100%. I do feel the jury was smart. I want to give credit to the jury, because I do think they were smart enough to win through that, and see through the bias that each expert would pose, obviously being hired by both parties, and especially after seeing Dr. Spiegel, especially after seeing someone like Dr. Spiegel, who literally diagnosed him because of candy, like literally eating candy, literally pirate movies, like what did you make of him? I gotta ask, if you had him, if you saw this witness, what would your reaction be?
Well, when I did watch it, what I thought was, he's up there cashing that check and saying what his opinion is, but he's not the problem. Somebody decided, let's put this guy up here to say this stuff. And the scary, terrifying thing for the Amber Heard situation is, what if that's the best expert who would take their side? That's what I thought. I'm like, oh man, then I don't think he was got in a car crash and hit over the head and suddenly became like that. Like, he was probably like that when they hired him, saying, well, yeah, I'll just watch the director's cut of Pirates of the Caribbean. I can tell you whatever you want to know about this guy. Like, what in the hell are you talking about? And so then the judge is like, he's like, do I have to answer that? And she's like, yeah, bro, you're a witness. That's what you do, is answer questions. That's your whole job here. So, that was not good. It was funny, but it was bad for her case, in my opinion.
I still can't get over it. I still can't get over that guy. But yeah, so of course, seeing the bias of the experts, I do want to ask, how important are experts in a criminal and a civil context? Like, are they different in any way, or what's their importance in the legal system?
Well, they do get to give opinions on things that can be involved in determining the case, and the normal witness can't do that. So that's the whole point of an expert, is they explain this thing and they can give an opinion. And I'll flash it back, because I just watched this case, the Murdaugh case, where they had the experts for the defense. The guy who was from right here where I live drove down there and testified about the height of the shooter based on calculations he made. He's an engineer, smart guy. But he was able to say, well, I think the shooter was this height. And if the shooter was that height, that would exclude the defendant. So he was allowed to give this opinion. So if he's believed, that's very important, because he's doing something other witnesses can't do. They can't derive that opinion and offer it to the jury. But it's up to the jury, the weight of experts. And like you said, we often get lucky that the juries do a really good job of ferreting out what's worthwhile evidence and what isn't. And it's just random kind of who ends up on the jury. But my experience in juries is they try to take the case seriously. They just generally do. People rise to the occasion, and maybe it's the setting and, of course, the good nature of a lot of people, but they really try to do a good job in deciding cases. They try to be fair. That's my experience. And it's one of the best things about the justice system, are the random people who show up and prove that there are people who will try to do the right thing. So I like that about jury trials.
Yeah. How did you assess Judge Ascarel's performance? Like, what did you think of the way she handled the whole case?
Yeah, that's interesting, because people watch cases and they develop strong opinions on the judge, which they should, because the judge is a central character. The judge is the chief referee of this game and makes all the decisions. And people get very vocal about refs if the case isn't going the way that or games don't go the way they want, but also the objective performance too. So to me, I liked her. I thought she was striving to be fair. I didn't think she was trying to unduly dominate the proceedings or trying to make them any more circus-like than they were. It was a case that was high profile. She tried to give timely decisions to people, and it's not always about necessarily did she get everything right, because they have a remedy for that, the appeal. Yeah. But she's got to give them clear decisions, and she did it. And I think she tried to handle the case the best that she could and keep some decorum and keep it even between the sides. That was my impression of her. I liked her. Not everybody did, I think, but I certainly did.
Yeah, like it's quite interesting that you liked her. I think there was quite a couple of lawyers that were kind of that I was watching during the whole stream that was a bit not stringent, but a bit frustrated. That's the correct word. Frustrated in how she ruled in matters of hearsay. We've had two conversations about this about hearsay. Now, what did you think about how she handled it? Like was she wrong in it? Like, did she misapply the law in handling hearsay? First, let's go with handling hearsay in the live trial context before the other areas.
Well, when you have a trial as long as that one was, it's unlikely that she's going to not produce a decision on an objection during a live context that somebody won't have a fair reason to disagree with. You take a game like, say, basketball. Was it a charge? Was it, was it blocking or whatever? And a lot of it's down to how that person perceives it at that moment. And the appellate courts give some discretion to the trial judges because of this, because otherwise you'd just be redoing every single trial if you were examining everything that the judge did. So I'd be surprised if there wasn't a decision where somebody could go, I think she got the wrong end of this one, or even I might think that in certain cases. That doesn't make her performance bad. I mean, it's easy to watch it and imagine how you would do it, thinking about only this thing, but she's dealing with this whole thing, and not all of it's on TV. I mean, she's got monitors there, stuff's going on, there are open issues, more than one case. There's lots of things happening in her life. So there was nothing going on there that I thought, well, this is a big game changer here. Boy, does she wreck this trial. I can't believe this. And if it had been so abundantly clear, I think it would have been a stronger appeal from the side who was butthurt about that. I mean, both sides, Depp and Heard, said she made mistakes. That's what you have to say when you appeal. So they both were critical of her in that context. But I assess their appeals as not likely to succeed, and so that means I think she got the law right for the most part. But hearsay is super confusing, super confusing when it gets into details and just like leading questions. I mean, I don't remember if it was that trial or one I watched before where the person started responding to being accused of leading by putting "if any" at the end of their sentence. Well, did you go to the store and buy fruit? And it's like, no, if any doesn't make it not leading, Judge. What are you doing, Judge? Oh my God, Judge.
Yeah, it was definitely the Depp Heard.
Okay, well, if
because
that was what she did about the leading, she's not right there. It's still leading, Judge. Come on. Doesn't mean I don't like her and think that she was trying to do a fabulous job. But that one, if that was that trial, I remember laughing about that a lot, and even saying it at home sometimes.
Yeah, I mean, it was Elaine Betterhoft, and it was Camille objecting on a redirect. So this was I forgot what was it called, the most objections in I don't know, probably trial court history.
It's been suggested by Ms. Vasquez to you in your questions, the TRO. Is that true?
Objection, Your Honor. Leading.
What if any? All right. During the time it was happening.
Objection, Your Honor. Leading.
That's not offered to.
And hearsay.
Sustained.
Your Honor, it's prior consistent statements.
It's leading. It's sustained. Next question.
Okay. You tell to anyone about the abuse.
Objection, Your Honor. Hearsay.
Sustained.
Your Honor, may I approach them?
That's fine.
Look at him.
Can you name them?
Objection, Your Honor. Hearsay.
I think she can. It's not offered. It's just to show.
Objection, Your Honor. Can we approach? This is again
in fact, head after the divorce.
Objection,
correct?
leading.
Did you or did you not consult an ENT after the divorce?
Objection, leading.
Did you produce medical records to the defendants relating to this?
Objection, leading. Calls.
Right. I'll sustain the objection.
Thank you.
It's leading. Next question.
Your Honor, if we could, witness could be instructed not to answer until I've lodged my objection.
Wait for the objection, please.
Could we bring up defense?
Told me was
objection, Your Honor. Hearsay.
All right. When there's objection, please stop talking. Thank you. All right. I'll sustain the objection as to hearsay.
What, if any, you were asked if you had? It was suggested that you had not produced this in discovery. Is that true or false?
Objection, Your Honor. Leading.
Your Honor, she absolutely did that.
It's leading. It is leading question, though. I'll sustain the objection as to leading.
hundreds of thousands, I believe. Maybe.
Objection, Your Honor. Lack of foundation.
Okay. All right. I'll sustain the objection. Next question.
Relating to your nose.
Objection, leading.
Sustained.
Foundation, hearsay.
What if anything? That is not the cure-all. It's sustained.
You learn about your nose.
Objection, Your Honor. Hearsay.
I'm not asking her to tell what they said.
No, I'll sustain the objection.
What, if any, production for medical records with the ENT?
Objection, Your Honor. Lack of foundation.
Do you recall? I'm trying. Records reflect about your nose.
Objection, Your Honor. Hearsay.
I'll sustain the objection.
Please describe those to the jury.
I have
I'm going to
a bunch of scar tissue.
I'm going to object to the extent it calls for hearsay and lack of foundation.
Overruled.
And improper expert opinion.
Well,
she can certainly testify to.
We'll see where it goes. Go ahead.
Okay.
I have a significant amount of scar tissue in my nose.
Objection, Your Honor.
I'll sustain the objection.
What, if any, difficulty do you have breathing?
Objection, leading.
What, if anything? And that does cure on
No, it doesn't. But
Decisions like that does make it look like, oh, that's outrageous. Like, she could even get a question in, like, all these things. But then when it comes to, like, the therapist notes, all of those things, like, that are regarded as hearsay, and also these leading questions, why are these rules of evidence created? Like, what's the purpose for these rules of evidence?
Well, in general, the rules of evidence are supposed to support the reliability of the evidence that the jury's going to hear. So if it's a piece of physical evidence or a photograph, you have to authenticate it. You can't just throw it up there. You have to establish the basis for it. And for witness testimony, the law prefers greatly live testimony in court to the matters being discussed, and not things that are outside of court. So that's this whole hearsay thing, is a statement made by somebody outside this current hearing that somebody wants to introduce for the truth of it. That's your basic hearsay definition. Now, some things are excluded from that, and there are lots of exceptions. And like this example you just gave us, say therapist notes. Mm-hmm. Well, there's an exception to hearsay for what somebody says in trying to get a medical diagnosis or treatment. Because in theory, the law says, well, somebody's not going to be lying to their doctor when they're trying to get help from their doctor. So that can be an exception unless it's shown that they were really just trying to manipulate this to create trial evidence. Then it can be excluded. What about the therapist notes? Because the therapist in theory could come on the stand and say, she told me this in order to get medical treatment, maybe because it was in seeking it. But if she's not there, say the therapist isn't there and you want to introduce the notes or whatever, well, now you've got a document. So you have to have somebody there to authenticate the document if the other side won't agree to it. And then you have to show that document as a medical record and counts as a medical record. And then you've got this document. And then you've got the statements in it, which are also potentially hearsay, say what Heard said. And then you got to get that in as trying to seek medical treatment. So you have all these layers. And then if the time is so wrong, as you're pointing out, now you move from the 800 series rules to the 400 series. And you say, well, the probative value of this, in other words, how good it is at illuminating the truth for us, can be outweighed by unfair prejudice, or I just don't think it's relevant because it's outside this time frame. So there's so many rules at play, not just hearsay, but hearsay, of course, is that's a good one to object to, hearsay, because every judge, everybody's going to have to stop and think for a minute because there's so many exceptions and what the hell's going on here, and is it for the truth of the matter asserted? And that's a good one. If you're going to object and you don't know why hearsay, Your Honor, and get that one out there, and that gives you some time to think of what you're really talking about.
Yeah, I always say this as well, because there was also a piece of evidence that could have come in. It was Amber Heard's arrest. That there was a literal document, of documenting the arrest. It wasn't to prove the truth of anything. It's just a document. You understand? Like, she was here. She was arrested for XYZ. It's here. And that was not allowed in under hearsay grounds. Not because of Rule 800, which I believe it goes under the rules of evidence of hearsay, but what you said in regards to Rule 400, which for anyone that doesn't know, it's you say it because you're the lawyer.
Well, you got rules about, again, whether the unfair prejudice, and that is often a reason why things are kept out. It's like, I'm not going to let you talk about that because it doesn't help us see the truth of what we need to hear, but it sure makes this person look bad for another reason. And there are independent rules that deal with character evidence and prior convictions and things like that, because for example, say again, referring back to the Murdaugh case, what the DA wanted to do there was show this guy's a flat liar. That's all he does is lie. And he wanted to do that, so you would think he was lying about the murders of his family. So they absolutely were trying to associate his character and his behavior to that. And so there are limits on that, because you don't want people to perpetually judge maybe for one bad thing they did in the past. If the state has evidence beyond a reasonable doubt, it should be able to prove its case without slandering this person as a bad person. Show me the evidence for this case. Yeah. And that bleeds over into the civil context, not as tightly, but it's still the concept of what you're talking about is similar. Yeah,
completely understood. So yeah, that's the precise purpose why I alluded to that, because I actually believe a lot of people on Depp's side, well, I'm not sure, actually, let me not say it. Actually, yeah, let me say it. A lot of people on Depp's side, I actually thought that this was an error, so to speak, that she should have accepted the police record to come in. But I'm like, no, if the jury saw that and saw that, she did assault, that is incredibly prejudicial, because they're going to be looking at, well, she did that to her, she done it to him, and that's not the point. That's not the point. It's to, as you said, it's supposed to probe further to find out the likelihood of this thing happening from what you said, and I guess the flipping, I just went blank. I hate this. I hate when this happens.
That's my normal state of being, so I'm with you on it.
That's it. Great. So so when I look at decisions like that, yeah, my brain just went into overdrive there. So when I look at decisions like that and weighing it up in terms of the reality of the case, I personally thought that she did run a fair ship, because even with that decision, she allowed newspaper clippings to come in of reporting of that. It was to, and I could see that rule playing out. It was to probe, is there a possible chance of this happen? So rather than present the police record, which is harder to refute, presented this one, and I look at it, I'm like, yeah, it gives her a chance to, attest to that and say, oh, no, the girl came out, refute all of it, this, etc., this and that. That didn't happen. John, you understand what I'm trying? So, my next question would be, in terms of rules of evidence, in terms of hearsay, in terms of all of this. You mentioned that you worked in Europe. Which part of Europe?
Well, our company was based in Switzerland.
Yeah, okay.
But I would only be over there for dealing with things that were happening over here. So fortunately, I didn't have to do with the law over there. They had a different lawyer for there. And of course, European law is way different than it is in the U.S.
I was literally about to say that. That's why I asked, because there was a UK case. I'm not sure if you're familiar with the UK case. Have you heard of the case between the Sun and Depp?
Only a little bit, but yeah. Yes.
I will say this, because I think it'll be kind of unfair for me to, because the hearsay over there is, in my opinion, is completely more relaxed than what you have in the States. But there was a ruling that the judge made, and it echoes back to what you said earlier, where the courts value your life testimony, and place a lot of value on it, which is why hearsay exists, really. So in the UK, the audios that Depp presented in the US case, that was actually barred. And when I read the transcript, well, the documentation, the judgment that the judge done in regards to the audios not coming in, he actually kind of cited the hearsay rule, and he didn't cite hearsay or say it's hearsay. He basically just said he prefers her testimony under oath, where it could be monitored, stress tests, etc. All those, it can be controlled, basically, and he's not going to place weight on these statements out of court. That's what he said, and I read that as hearsay. But I was like, I mean, would you ever see that in the US system, where your audios that happened at the time of you saying all these things, where it's completely disregarded?
So usually, if it's the other side, the other party, it's going to be admitted as an admission of a party opponent. So usually, you will be able to bring it in. If it's somebody other than that, often you would not, even if it's an audio, no, unless it comes under some hearsay exception, because it's an out-of-court statement, and there's only limits to that. And particularly, if you have statements regarding the trial and stuff, yeah, as you pointed out, a lot of the rules for testimony involve the ability to cross-examine, with the obvious idea that it's not fair to let somebody assist you in your case and testify for your case, and the other person can't even challenge the evidence. So sometimes you'll see remote situations where there'll be a recorded deposition. Well, even a deposition is hearsay, but it might be allowed in if the other party had a chance to cross-examine, and there's certain procedures followed. Sometimes you can use that as testimony in court, but not automatically, or Zoom or whatever.
Oh, so what you're basically, would that be under prior inconsistent statements? I'm guessing.
Well, under. Yeah. So for example, if you have a deposition from some other proceeding, then you can't bring it in, but necessarily. But you can if the witness is up here and they say, "Well, I never saw that person," and then you can bring it in as a prior inconsistent statement. Okay. But sometimes you can just have it as its own testimony. Like, let's say the person lives in Florida and the case is in Virginia, and they can't travel to Virginia because of medical condition. There'll be procedures where the judge will let you go down there, and the other party can cross-examine, or this, that, or the other, and you can create a deposition that's actually usable in court. Or if the parties are the same and there's a cross-exam, there's a lot of intricate rules for being able to use in court here testimony that occurred somewhere else. But prior inconsistent statement is an exception anyway. So, but I'm talking about if you want to affirmatively bring it in as evidence, then you have to make sure that, all your T's are crossed and I's dotted and things that you met all these requirements. Otherwise, it isn't fair to let people support you, but not be subject to any questions about it.
Understood. So Okay. So in this case, Depp was the plaintiff. So, and I think you just said in regards to if you were a witness and you're trying to bring in an audio, that will be dismissed unless it passes the hearsay exception. Did I get that right?
Yeah, that's generally true. Mm-hmm.
So in the case that I referenced earlier with the son and him, he was the party. So in the US, would he have been barred from producing that evidence?
So if you are a party to the case and you have audio of the other party, you usually can bring that in as a statement by a party opponent. So
usually.
Yeah, I mean, you've still got to authenticate.
You can't. Sorry.
Like, for example, you got to authenticate the recording. You have to show that it's really them. And it's possible that, something could be said. For example, let's say the person's on the audio recording going, and it's for this Depp thing. And then Depp's on it. Well, I murdered somebody 42 years ago. Then the judge might have you edit that out because of these other rules about prior bad acts and that aren't relevant to this. That was a terrible example. But the point is you don't necessarily get to bring in everything recorded, but
relevant.
And it's built into my DNA as a lawyer to say things like it depends and generally and stuff, because there are just so many exceptions littered. But usually you would be able to bring in a statement by the other side made to somebody, recorded video, or even just made to somebody. And then the person comes in and says, they told me this. In England could be different, of course, and it probably is. Their defamation law is certainly different.
Yeah.
And it's also the case that the judge could look at it and go, well, I heard this, but I give it no weight because this person testified in front of me, and that's what I'm paying attention to. I mean, I don't know. There's lots of ways for it to lose its power, either being excluded from court or included, but then dismissed as not something that I care about, kind of thing.
That's a very fair point, because in the UK case, it was one judge that was presiding over the case, and then this case in the US, it was seven jury members. So that does play a massive part, because of course I think that's where prejudicial and etc. would come in, because you're facing jury members rather than a single judge who I assume will be able to weigh up these values.
Yeah. So if you have what's called a bench trial in the U.S., which is when the judge is not only the judge, but also the fact finder, which is normally the jury. So if you do a bench trial, then the judge could say, well, yeah, I'm not paying any attention to what this recording of him on the street, because I think they were just joking. Then I believe this thing. This matters to me 100 times more than what you tried to trick him into saying on this tape order, because it is appropriate for the judge then to weigh the evidence, because they're the fact finder. Normally it's the jury.
Okay. Yeah. Okay. Do you think that this case would have gone any different if it was a bench trial? That's a very loaded question. I do apologize.
Yeah,
that's a very loaded question.
Well, with 2 points of answers. One is I think they did make this motion, because everybody always does, and I think I even read it after the case is over. That the side that loses is going to ask the judge, make a motion for the judge to throw out the verdict, that this didn't happen. They didn't prove this or that. Now, in theory, the judge could agree with you that I wouldn't have voted with them either, but the jury gets this level of latitude. So here, the judge didn't throw anything out. So you got to decide, was the judge saying, well, this was within the latitude of the jury, or was the judge thinking it was within the latitude of the jury, but also I agree with them? I tend to just guess here that the judge probably saw it the way the jury did, but that's just guessing. I think she probably would have done the same thing. That's fair.
I mean, I do want to ask the question, and I do want to go into. There was a potential legal issue that I observe. I'm a nobody, so it don't really doesn't mind the end what I think. But what did you make of the decision to include Amber Heard's counter claim in regards to Waldman's statements? Like, how legally sound was that decision? Because Depp didn't say it.
Yes. Now, okay. So 2 points there. One is the strategy to even file the claim. by Amber Heard's attorneys to make this counterclaim instead of just looking like I don't even want to be here. Now she's got a claim and she's throwing it at him saying, no, you're the bad person. So that happens, of course, a lot. You love that. I mean, I've been in some cases when I was younger that, if you think your client's going to get sued and you have a counterclaim, you sue first, because then it looks like you really believe you're the aggrieved person. Let's go, and you pick the court. Let's go ahead and get this ball rolling. So it certainly sounds strategy to file that. And there are other benefits to having a counterclaim, and not least of which is they won on it. They got an offset of some of the verdict against her by winning on part of the counterclaim. So, and it puts a risk to the plaintiff locally. Not only can you just lose this case, but you may owe me money at the end of it.
Yeah.
And if they'd been more interested in settling, that might have mattered. So now, in terms of what the judge did with it, the question really is whether it was right to instruct the jury and to let the case proceed as far as it did, that he could be liable for the statement of the attorney, whether that attorney counts as an agent under Virginia law or an independent contractor, and whether he was acting within the scope of his agency. The jury instructions were all there, and it assumes that the law would comport with that. The weird thing about Virginia is they didn't even have appeal right at the appellate court level until just during this case. So they expanded the Court of Appeals and things like that. So one of the weird things about Virginia is they have not nearly as many Court of Appeals decisions as other states do. A lot of other states, for a state of such significance as Virginia, there's a lot of law that hasn't been laid out. And sometimes you'll see the federal court, when they're trying to apply the state law, saying, well, we're just going to have to guess what the Virginia court would do here because they haven't had to say yet. So some of this stuff about this agency stuff, I heard some other lawyers talking about it who felt like the judge made a mistake there. And I think the reasoning for the cases they were looking at was sound. However, there are other cases that would agree with what the judge did, and there's no case directly on point. If there were, it would have been in Johnny Depp's legal team's brief, and it was not. There was no direct case from Virginia saying this is the law. And if there had been, that would have closed the issue. So it was an appeal issue for her, for him to say that that was a legal error on her part. But I still think there are some cases, some courts say, where you can be liable for what your attorney says, depending on how you directed them and things like that. And it probably was a loser, in my opinion, but other lawyers have said the opposite. We're never going to know because, of course, they settled out the appeal, so the appeals court doesn't have to clarify this issue.
Yeah. So that's a very good point you brought up. So in regards to Virginia, do you think is because it's the Commonwealth that they are like that, or that has nothing to do with it?
It's just because they're weird, and I can say that because I was born in Charlottesville. I mean, that's where I'm from. Is from way out in the middle of the country of Virginia, and their whole procedures with rules and things like that, like they really kept their own way. Although they're getting more like other states now, but it's just the processes they had. And I don't know that it's better to have gillions of appellate court decisions because they get contradictory. It's cost a lot of money to do appeals. And what they really were doing in Virginia is saying, when you get a decision from the trial court, unless there's something big time wrong, that's your decision. You live with it. They trusted the trial court at a state level at that much, right? Because that is a decision. And they're saying, well, there's a good chance you can't even appeal that to us. You just got to take what you get. Whereas other states are like, well, you can have one appeal. And in North Carolina, if you get a dissent at the Court of Appeals, then you can go to the Supreme Court. And so every state's all different. But it was very, hey, one shot and one strike and you're out is how Virginia handled it.
Understood. So what was, looking at their appeal arguments and all of that, we know that they're settled now, so it's kind of a irrelevant moot argument to make. But actually, scratch that question. Based on their settlement and all that's happened, what do you think the legal ramifications of this might be? Like, would it have a seismic effect where you will see other states citing this case to say the attorney is responsible for what is being said in the media, like etc. The reason why I ask that is because there are a lot of Me Too lawyers that do speak for the attorney. For their clients. Oh my days. And even Elaine went on and done a whole tour saying that Amber couldn't afford a lot of these things, etc. You know, is she liable for, you know, are those now Amber statements, etc. And even in the Gabby Petito case, I'm not sure if you are familiar with that case, it was even cited that the attorney for the Laundrie family, you know, based on what he was saying, that those were Laundrie's mother's, you know, the Laundrie family's words. Like, what is the legal ramification based on this decision alone?
So in a Petito case, I had looked that up because I had some interest in that case, because I had been where they were right about the time they went there, when they were out at Moab, and we were watching that. Anyway, obviously the ending is terrible, but I have to admit that I can't remember the answer that I found. I was looking at the law down there because of this precise issue. But to answer your question, I think it won't impact other states for two reasons. And one is, other states look to their own appellate courts for what their law is. Now, when the appellate courts make the decision, they can look at other states and go, we like, you know, we're in Virginia and we like the way South Carolina decided this case. We find this reasoning persuasive. We'll adopt it, but it's not any precedential authority for them. Oh. And you could even at the trial level, when you're arguing with the judge, you could bring in a case from Nevada or something like that. But the other judge is going to start looking at you. When you're quoting cases from out of state, is telling me you got no law in our own state. There's nobody that controls me that's decided this. So you're into the persuasion and reasoning, and this looks more like an apple than an orange. And that's how it goes. And then when it's just a trial court decision, like it is up here, where you're just reaching a jury verdict, no one's going to pay any attention to that from well, you have to do it this way because the judge up there did it that way. It's even less of a precedent because it's just a trial court decision. It doesn't have binding authority on any other circuit court. What she did in that court doesn't bind any other judge in Virginia to do anything. Only the appellate courts do that.
Okay. So, So I guess my next question would be, and this is just for my own curiosity, I think this is going away from it, but if it did get to the appellate level and it was affirmed, would DEP have to pursue it to the Supreme Court level to have it? No. Am I asking that question properly? It gets to the appellate level. It's affirmed, so now it becomes president. The next step would be to take it to the Supreme Court of Virginia, I'm guessing?
Yes, but they get to decide whether they want to take the appeal or not. You don't get an appeal of right. I don't think. I could be wrong. Everything's different, but you have an appeal of right, is my recollection in Virginia, to the appellate court level, the Court of Appeals. And after that, I think it's just up to them if the Supreme Court wants to take it. I'm not certain on that, but that's my recollection. But yes, if they affirm the judge's decision, not only would that end his argument over it, that would be the law of the state, unless the Virginia Supreme Court were to take it up then or on some future case and say, nah, you guys were wrong. That would become the law of the state for all the judges. Okay.
Well, you just answered my question there, because I was going to ask if DEP has to pursue it to the U.S. Supreme Court to have it reversed, or can it just or can they step in and reverse and be like, nah, this was actually wrong? Like, I was trying to find out what would be the procedure to go through to have it reverse, whether it would need somebody else doing it. But as you just said, it's basically if somebody else was to have the same case and then they're like, no, we go with this one because that one was wrong, even though this person affirmed it at the time. Yeah, am I in the right understanding? Or
so if it goes up to the Court of Appeals, and let's say they go, nah, the judge was right, you can be liable for what the lawyer says, and then DEP doesn't go to the Virginia Supreme Court, either because they won't take it or because he goes, oh, screw it, I've had enough paying lawyers, I'll just take my medicine even though I still think it's wrong. Well, that becomes the law of the state, that Court of Appeals decision, and it'll bind all the judges all over the state, unless either the Virginia Supreme Court takes it up on some other case later because nobody appealed out of this case, or the Court of Appeals later on reverses itself, that's pretty infrequent for that to happen. That's pretty extraordinary. They can, but I mean, you're talking about a rare thing.
Okay.
You know, they generally don't.
Is that they would do that? Like they just get out of nowhere and be like, you know what? Nah, we're just gonna reverse that. What would the circumstances be in that?
It's really rare, but again, since I'm a lawyer, I have to throw it out there. I mean, hypothetically, they could say, well, we think this has changed because of this, and like look at the United States Supreme Court. They typically will accept the precedent of prior Supreme Court decisions. Every once in a while, they don't. And so, you know, like on the abortion case, they changed the law on abortion. And sometimes what they try to do is they try to avoid reversing their own decision, and they'll just clarify it or they'll modify it or whatever. But sometimes they just go, nah, that was wrong. And so it can happen, but it's highly unusual.
Yeah. Okay. We have come to the end now. I really appreciate you sitting down and talking to me in regards to this. There is one more question I do have to ask. There is one more question I do have to ask, though. Based on your experience, like, do you think this case was handled properly, or it was just a miscarriage of justice? I'm not talking about the verdict. I'm just talking about how it was handled, like from witnesses to expert witnesses, jury, etc. Because there were so many things that was talked about, like Jewish sequestration and all of that. So, how was it handled?
Well, yeah, I think it was fine. It was, you know, the public has a right to have an interest in cases. They don't have a right to have a broadcast, of course, but the judge tries to accommodate that if it's not going to prejudice the parties. Like the Lori Vallow case out in Idaho was terrible, but the judge is not going to allow any streaming of that. That's a criminal case, but nevertheless, I think the judge handled this one pretty well. It got a lot of commentary that's over the top from every side, but that's because this case was about such a larger issue. Not, you know, and then Johnny Depp has, like we said, so much charisma, and people were interested in Amber Heard too. And so that just brought this like perfect storm of everybody wanting to comment on it. And once you get the flames going, then you get a super fire happening and everybody talking about everything. And I don't think that's the judge's fault. I think the case was fine there. Yeah, I don't know what the lessons of this case are,
if there are any.
if there are any, other than, as we always say, every case needs to be judged on its merits, and hopefully, you know, there's a lesson learned, and this probably is on Johnny Depp's side, and maybe on Amber Heard's too. I hope she becomes a better person for this experience, but that's up to her.
Thank you so much.
Absolutely.
Yep. For saying that with me. Like, what's your socials? Like, where can people find you? Plug yourself, like what's your YouTube channel, etc.
Yeah, YouTube channel is Southern Law, and as we discussed, what I try and put on there is just the legal aspect of things. But I also am on Twitter and encourage everybody to not find me there. But I do enjoy talking with you on it because of your enthusiasm about not just the facts of the cases, but to learn accurately what the process is that the people are going through. I certainly really appreciate that. That's been a lot of fun for me to engage with you on that.
Thank you.
Absolutely.
Thank you so much and thank you for the kind words. I will definitely, if I see any brain date tweets, I will definitely tag you. I might even make your own monocle for you, like because I see you have a pirate flag, so I'll just tag that in and tag you in it, like, help, come help me here. But yeah, thank you so much for sitting down with me, and I'll speak to you later. Hopefully we can do this again. Hopefully we can collab again, because I really love covering cases and looking at cases, and it would be amazing to speak to you again.
Well, if this OnlyFans case goes off down in Florida and you're going to cover it, I'd be interested in that one. I certainly have an opinion on the facts in that case, in addition to whatever the law may be.
Definitely. Thank you so much for joining once again, and have a good day.
Sounds good. You have a good day too.